we have many prospective clients who come to us and maybe their loved one or family member was living full-time in Florida and they're now planning on bringing them back into New York. We can discuss doing asset protection planning and trust for Medicaid eligibility. There is no durational time that they must have lived in New York. Really, once they kind of move into an apartment or a home, we can proceed. So that is something that's great to know because, again, federal program run by the states. Other states will have durational residency requirements. So you're not eligible until you've lived in the state for 6+ months. This is kind of a little snapshot of the eligibility thresholds. This is important because it gives the context of why we're doing asset protection planning. Medicaid in New York is a financial means tested program. What does that mean? A person applying for Medicaid must have below certain eligibility thresholds. So currently in 2022, in order for a single individual to be financially approved for Medicaid, whether it be community home care Medicaid or nursing home Medicaid, they need to have less than $16,800 in non-retirement liquid assets. They're allowed to have what we call an irrevocable burial trust account. That's also known as a prepaid funeral. So the thresholds are going to be the same for either program. So if you or a loved one needs care at home or needs coverage of room and board in a facility, you're single, you need to have less than $16,800 to your name, non-retirement monies. There's income thresholds that are listed on this chart that doesn't really come into play when we're discussing asset or trust because we can't protect your income in an irrevocable or revocable trust. Something we can briefly discuss at the end is what's called a pooled income community trust. That is a great tool for individuals who are receiving home care Medicaid because the threshold or what we call allowable limit for income in the community is $954. What that means is if you're applying for home care Medicaid, you will be financially approved given your assets are below the $16,800, but your income above the $954 a month is considered your surplus or your spend down. You owe that to Medicaid by turning it over, or you get to shelter it in what is called a pooled income community trust. So that is really a great thing to be aware of if you or a friend, a loved one is going to be applying for home care Medicaid, because unfortunately, I would say it's not a very widely known program. So unfortunately, we'll have clients who come to us and say, oh, my mom's been on Medicaid for 3 years, but it's getting really difficult because we're turning over her spend down every month. You don't need to pay a spend down or your surplus to Medicaid. You can keep that income. It's very difficult, I'd say almost impossible to reside in Westchester County on $954 a month. So pooled income community trusts are a form of trust that are a great tool when we're discussing protecting income. The trusts we're going to focus on today are not for the protection of income, they're for the protection of assets. When we have a couple who's applying for Medicaid together, the thresholds are a little bit higher. And we also have what is called a community spouse. So community spouse is the individual who is not applying for Medicaid. They are the well spouse, the one who is not in need of either the home care or the nursing home care. They have certain thresholds that allow the ill spouse or the one who is applying to transfer assets to be able to allow for that individual to obtain Medicaid eligibility. I don't know, sorry, someone just popped up. I want to make sure they got admitted. So again, just kind of a breakdown of the certain thresholds when it comes to Medicaid. And if anyone, I know everyone's kind of on mute, but if anyone has questions, I meant to say this earlier, please feel free to just unmute yourself or kind of you can raise your hand through the chat. I'd be more than happy. And I'd like to kind of, if there's something that's confusing or you want emphasized a little bit more, kind of jump in. But I will have time for questions at the end. So spousal refusal is a tool that is most commonly utilized when the well spouse maybe does not want to put all of their assets in the Medicaid Asset Protection Trust. or we are at the time of quote unquote crisis and an individual is in need of nursing home Medicaid, which we'll discuss briefly, has what's known as the 5-year look back period, which you may have heard about, meaning Medicaid is going to look at the financials for the Medicaid applicant and their spouse for the past 5 years. If there's been any transfers of assets within those 5 years, there's going to be the implementation of a penalty period. So if I'm going to be applying for Medicaid, let's say I have $100,000 in my name in non-retirement monies. I'm not financially eligible for Medicaid because I'm above the $16,800. I can choose to transfer those surplus monies to my husband, and that's an exempt transfer. I will not be penalized for my Medicaid eligibility. If I transfer it to the irrevocable trust, I will be disqualified. If I transfer it to a child, if they're not a minor or disabled, I will be disqualified. So if I'm now at the time of needing nursing home Medicaid, I don't have the option to do the protection of putting those assets in the trust. I really can spend down to become eligible, or I can transfer them to my spouse. If my spouse is above the certain threshold, which is what was on the previous slide, the community spouse resource allowance, right here, the CSRA, if they have more than 137,000, they're going to need to do spousal refusal, basically telling Medicaid, yes, I know in New York, I am legally obligated to support my spouse, but I am refusing to do so. Don't look to my income and my assets to determine my spouse's eligibility, look only to theirs. So it's a great tool when we are doing Medicaid for an individual and they either did not do prior asset protection planning, or if they did and were within the look back, we have to review the trust and see if we can get assets back to the individual's name. Activities of daily living, this is just what a person can get assistance with if they were to get care at home. Look back, we kind of just briefly were discussing home care Medicaid currently has no look back period. There was one passed with Governor Cuomo in 2020, but the implementation cannot come into play until the public health emergency ends. So what he had passed was a 2.5 or 30-month look back, so half of what we currently have for nursing home Medicaid. And that would be for transfers made retroactive to October of 2020. So that one, it was supposed to go into effect, but due to COVID and the continuing public health emergency, which was just extended again this past Sunday, that implementation has continually been delayed, which is great news for anybody who is in need of home care assistance. They can transfer assets, fund the irrevocable trust that we're going to discuss, apply for home care Medicaid the first of the next month and have no penalty. You cannot do that for nursing home Medicaid. That hasn't changed. There is the 5-year look back period. The thought is this new home care look back will be implemented in 2023. As of now, the earliest would be January. But again, if that public health emergency continues to be extended, it gets pushed off another quarter. So the elder law community is kind of in limbo. We're kind of continue to be in the sweet spot, meaning if you need home care Medicaid or considering home care Medicaid, now is the time to transfer assets and put the application in, so that if this look back gets implemented January of 2023, you cannot fund a trust, you cannot transfer assets out of your name to obtain eligibility without yielding yourself a penalty period for which you have to private pay. So the penalty period that I keep referencing is created by the transferring of either uncompensated transfers. So I give my house to my child and they've paid me nothing for it, right? I gave them an asset that's worth something and I've received nothing in compensation, or what we call a non-exempt transfer. So the exempt forms of transfers are what we briefly discussed, spousal exempt transfers. I can give everything to my spouse, he can give everything to me. It yields absolutely no consequence for either form of Medicaid. You can transfer assets to a blind or disabled child, or to what we will also discuss today is called a supplemental needs trust or an SNT. The ineligibility or penalty period is calculated by looking at the total value that's been transferred, or the gift that has been made, and they use what's called the regional rate, which is the average cost of nursing home care. The regional rates, oh, here's the little chart that discusses the exempt and non-exempt. The regional rate for Westchester County is $13,399. That is what is presumed to be the average cost of nursing home care, when it, usually is much higher. But if an individual were to transfer $100,000 to a non-exempt individual, so not a spouse, not the blind or disabled child, and apply for nursing home Medicaid, Medicaid's going to take that $100,000 and divide it by the $13,399 and yields a penalty period, for which they're going to say, well, you gave away $100,000 that you could have used to cover the cost of your care, and as such, we are not going to cover the cost of your care. The penalty commences, and this is very important, at the time that you are eligible and apply. So there's a misconception a lot of times where an individual will say, well, I transferred the asset 3 years ago, so if I apply, I'm only going to get a 2-year penalty because there's only 2 years left within my 5 years. Unfortunately, that's not true. The penalty is based, again, on the total value of the asset you transferred divided by the regional rate. And if you applied at year 4, month 11, and it's, let's call it a 10-month penalty, the 10 months is going to start at the time of your application, even though you only had 1 month left on your, call it, look back. So very, very important, if you are contemplating filing, especially a nursing home application, having a conversation with an elder law attorney as to the implications of any transfers that have been made, any funding of irrevocable trusts, just to get another opinion to make sure that you're not causing yourself to, or the loved one, to obtain a very large penalty, for which you now need to appeal at what we call a Medicaid fair hearing. Estate planning basics. So before we get into the nitty-gritty of the trusts are crucial. They're very important. They're great asset protection planning tools, but the documents that I'm going to also briefly discuss, which is a little bit of a refresher if you did my power of attorney program, are, I would say, a must for anyone over the age of 18. So healthcare proxy, most individuals have one. They either did one through their doctor, they may have had a surgery or a procedure, and were given by the nurse kind of a 2-page document where you hand wrote in the individual you want to make healthcare decisions for you. That's fine. It's just very important that you have a document where you have appointed somebody to make any and all medical decisions for you if you're unable to. If you don't have a healthcare proxy, there is what's called the Family Medical Decision-Making Act. Basically, the next of kin would be able to discuss medical decisions. So for example, if I had no healthcare proxy, a doctor is going to speak to my husband before a child. But so for example, if maybe you want your child to make healthcare decisions for you, not your spouse, maybe the spouse, we have some situations, the spouse was recently diagnosed with dementia or some kind of cognitive deficit, and therefore the well spouse doesn't want them making medical decisions for them. They're going to do the proxy to appoint another individual to kind of say, look, I now of sound mind, put in writing who I want to make the medical decisions. And we want you to have a conversation with that individual you've appointed as to all of your wishes. We want them to be able to basically step into your shoes, know what it is you want in regards to tube feeding, organ donation. A lot of times I think healthcare proxy gets intertwined with what we're going to discuss called a living will and a DNR. All separate. The healthcare proxy is the document you're signing in front of 2 witnesses as to who is going to act on your behalf. And DNR is usually a document that you're going to deal and discuss with the medical professional, your doctor or the hospital, not an elder law attorney. We can prepare something called a living will. The living will is a document that discusses end-of-life decision-making. So if you are in, it has kind of a paragraph, it's the 3rd paragraph on the document. stating you are in a permanently vegetative comatose, no chance of recovery. You don't want to be kept alive by extraordinary heroic measures. So you don't want mechanical respiration, you don't want tube feeding, but you do want maximum pain relief. So that's kind of for your proxy to have in their back pocket as belts and suspenders if they ever have to make a medical decision for you. You know, God forbid you have a traumatic brain injury, there's no chance of recovery, and you're on now ventilator life support. If that is not what you would want, that's the conversation you're having with the proxy. When they have to have that conversation with the doctor, they're then going to be able to display that you, when you were sound mind, signed a living will in front of two individuals. I skipped over the HIPAA form. That is basically a document that most individuals have seen in their medical provider's office. If you need to send forms to another doctor, to a child's physician, to a hospital, et cetera, you have to give the confidential release of your medical records to another individual. We usually do a broad HIPAA for the individual you've appointed as your healthcare proxy, so they can make medical decisions for you, and they're also entitled and able to receive and obtain all of your confidential medical records. Power of attorney is, I don't want to say the most important document, but I mean, I've been an attorney now, I'd say about 9 years, and the most crisis stress that I usually see is when an individual did not ever sign a power of attorney, or they signed one, but they didn't use the valid form. They printed something offline. They didn't have it notarized, witnessed. They didn't initial in the right spot. You don't need an attorney to prepare your power of attorney, but it's very much recommended that you have a discussion with an attorney. As an elder law attorney, we view a power of attorney kind of, I'd say, in a different way than maybe a real estate or transactional attorney would. The power of attorney form in New York is what we call the New York statutory short form. There was just a revision to the form June 13th of last year. So if you were to sign a power of attorney, let's call it today, you want to make sure that you're signing the most current short form. It usually says, I think it's in the top left corner, it'll have, you know, last modified 6/13/21. Before that, it used to say September of 2010. So if you today sign the 2010 form, it's not valid. So again, you have to be very careful when you are going maybe online and you're typing in power of attorney. You need to make sure, and I can't tell you how many times someone comes to me with a power of attorney that they're, you know, excited that they have, and then I have to review with them, it's not valid, and unfortunately is not going to allow them to do what the intention was. So if a power of attorney is drafted correctly and executed correctly, it can be a great tool when we're doing asset protection planning. The power of attorney that we have, it's on the New York statutory short form, but then in what we call the modification section, we've added a lot of other authority and delineating provisions that allow for the agent to create a trust on your behalf. So basically, the agent under your power of attorney can create this irrevocable Medicaid asset protection trust to do maybe advanced planning for you, keep you at home to age in place and trying to protect some assets, because we don't have the crystal ball should you need nursing home Medicaid in over 5 years. So, you know, if you guys take nothing away from today's program, just if you don't have a power of attorney, I highly recommend that you consider doing one. You know, we all don't want to think about a situation where we're not able to handle our own finances or make our own decisions. But, you know, stuff happens, and we want to make sure that we have the person that we trust and who knows our situation kind of already set up. There's no delay. They don't need to pursue what's called an Article 81 guardianship proceeding, which is where they're then petitioning the court to be appointed the guardian to declare you an incapacitated person to handle your financial affairs. So just, you know, as I keep saying, very important. The agent has very broad authority, if again, all areas are initialed and signed, to transfer assets, to engage in that asset preservation. But if that's something you're uncomfortable with, it can absolutely, be tailored to your own comfort level. Maybe, we have some clients who want gifting limited to the annual exclusion amount, so the $16,000 per person per year. But you can have it be really, again, sort of like the healthcare proxy, an individual stepping into your shoes, but now to handle all financial decisions on your behalf. Last will and testament. This, I think a lot of times clients confuse with a trust and kind of how it operates. So I like to discuss it. A last will and testament is an important document, but the goal a lot of times is to try and create what we call a non-probate estate. What that means is not having an asset in your name alone, either without a joint account owner or without a named beneficiary. So if you have assets within the revocable trust we're going to discuss, or the irrevocable trust, they're not in your name alone. They're now owned by your trust. So the Samantha Lyons Revocable Trust, that assets that I put into that trust are not going to be controlled by my last will and testament upon my passing. The last will and testament is a document that's going to discuss who do I want to receive and what do I want them to receive from my estate. My estate is only comprised, again, of assets in my name alone, without a joint account owner, without a named beneficiary. So a Chase bank account in the name of Samantha Lyons, I never put a beneficiary designation, or maybe my beneficiary predeceased me and there was no contingent. That asset is now a part of my estate, and upon my passing, no one has access to it. The nominated executor has to probate the will. So another kind of misconception amongst people is that the executor that you've named has authority upon your passing. I get calls a lot. My mom passed, I'm her executor, I'm going to the bank today. Unfortunately, you have no legal authority until the will, the original, is probated in the surrogate's court for where what's called the decedent, or the person who died, resided, and the court has granted you that authority. So that's a process, that's not instantaneous. So if we need maybe expenses of a house to be paid, the funeral to be paid, that really is all tied up until the estate, you're obtaining what are called letters testamentary as the nominated executor, or letters of administration if maybe we did not have a last will and testament. So it's a great tool to basically specify who you want to receive your assets, but there's other mechanisms we're going to discuss to accomplish the same goal without maybe the delay that the filing of a last will and testament. Last will and testament, it is all public. So the probate petition, the assets that are listed can be viewed by anyone. So if maybe you're more private, you don't want anyone knowing what it is that you owned at the time of passing. Another reason to try and avoid a non-probate estate, there is the legal fee of retaining counsel to probate the last will. If you pass without a will, I'd say another big misconception is that the state gets everything. A lot of times when I sit down with someone, they'll say, well, I'm only here today to discuss having a will because I don't want New York State getting any of my assets. It's not that simple. So if you never do a last will and testament, and when you pass, you have assets in your name alone, those assets are going to be controlled by what we call the laws of intestacy. So that doesn't mean they go to the state. It's going to go pursuant to kind of a statutory scheme of your next surviving kin. So it's going to go first to the spouse, if not spouse, then children, down a bloodline, parents, siblings, cousins. So if you don't want certain individuals within that bloodline to inherit from you, then you want to put all of that in a will to make sure the laws of intestacy are not controlling on your estate. But really, it has to take all of the bloodline to predecease or not be present for the assets to then be held with the public administrator. So, wills are great, but if you don't have a will, that doesn't mean you're forfeiting your assets to New York State. a trust. So that's kind of, again, that was the focus of today's presentation. I hope kind of the background I gave is helpful for us to now transition into kind of the meat of the presentation. A trust is basically an agreement. So we have what's called the grantor. That's the person who's going to be creating the trust. So if I have the Samantha Lyons Revocable Trust, I am the grantor. We're then going to have individuals or corporations that are going to be responsible for the management of the trust. So that is what we call the trustee. You can have one person, you can have multiple people. We have clients who maybe don't want to involve family members or don't have surviving immediate family members and decide to have a financial institution act as a corporate trustee. That is absolutely permissible. The kind of cool thing about doing a trust is you as the client or as the grantor are really in full control. You get to decide the provisions that you want drafted and created within this document to control the assets that you then fund into this trust. So a trust can be revocable, revocable, irrevocable, irrevocable, kind of, tomato, tomato. In New York, you as the creator or grantor of the revocable trust, which, a lot of times people reference as a living trust. It's not a trust that was set up through a last will and testament called a testamentary trust. It was created during your life and used during your life. You can be the sole trustee. So the Samantha Lyons Revocable Trust, where I'm the creator and I am the sole trustee, it's going to be highly recommended and encouraged and almost always followed that there's going to be a successor trustee. So God forbid I become incapacitated, someone is going to be able to step up, sort of like the agent under the power of attorney, but only to the assets that are within my trust to manage the trust assets and income. So I kind of referenced this earlier. Do I need to be rich to have a trust? Absolutely not. Wealth is not the prerequisite to having a trust. The trust, is either a decision of wanting to do some asset protection planning, organizing your asset ownership, kind of consolidating assets together all within this one trust vehicle. There's certain trusts that are done for tax planning, wealth transfer planning. The other nice thing that we'll kind of discuss is within your trust, you can have the beneficiaries really set up in whichever way you choose. So if I have a bank account at Chase, I can name beneficiaries. I can say if I predecease, it's to my husband, if not my husband, then to my children. But I can't really get into nitty-gritty details of how I may want those assets to be distributed. In my trust, I can say all to my husband and have what is called the disclaimer trust provision. What that means is if the assets I'm giving to my husband are above the estate tax threshold, he can disclaim the assets above that threshold, right? With a named beneficiary, we can't do that. The individual is just getting what it is that you had. For my children, maybe I don't want them coming into assets, at age 19. I can put language in that they are to get distributions at certain age thresholds. They get it all outright at a certain age. If someone were to become disabled, we can put in language that the monies continue to be held in trust so it doesn't disqualify them from any sort of state benefits such as Medicaid, SSI. So way more control by using a trust to distribute your assets, whether it be 50,000 or millions of dollars. I mean, again, wealth is not a prerequisite. And avoiding probate is also another reason why a lot of people want to have a conversation of doing trust planning. Some of the cons. So I know I've been discussing a lot of misconceptions. One of the big misconceptions of when doing a trust is you've signed the trust and now all of your assets are owned by the trust. That's unfortunately not the case. It's kind of a two-step process. The attorney is going to prepare the trust. You're going to sign the document as the grantor and maybe as the trustee, or you're going to have other individuals who are going to need to sign. Depending on the type of trust, we either use your social security number to open an account, or the trust will have its own tax ID number, or what we call employer identification number, or EIN. you then have to go to the financial institution and open a bank account in the name of your newly created trust. So the paper that we've created in the trust, right? That's just the vehicle for which now you need to transfer and fund. So if we're putting real property into a trust, it's the signing of a deed. Your property is not owned until you've actually signed a warranty deed transferring whatever ownership interest you have into this trust. Same goes for bank accounts. You open an account in the name of the trust. There's really, I'd say a popular question is, well, what type of account can I open? There's usually not a major limitation. You can have checking accounts, savings accounts, brokerage accounts, and then the way your trust is structured is whether or not you have access to principal or you have access to income, which, we'll get into. So very important to be aware, and it's something that we kind of harp on and we put in a letter multiple times, that just by signing this trust, the trust doesn't own anything until you actually effectuate the transfer. So that I would say is a quote unquote con, because there is an extra step to actually get the protection of what you are intending. Most of the trusts may require an additional tax filing, meaning if you do a irrevocable trust, if it's what we call a completed gift, so a children's trust that we'll discuss, or a life insurance trust, there's going to need to be a separate tax filing because it was a completed gift. The irrevocable trust that we do, or what are called Medicaid asset protection trusts, it's not a completed gift from tax purposes until you as the grantor pass away. Revocable trust I've talked about many times. That is, again, while you, the grantor, are alive and can be used for your benefit. The way I like to think of the revocable trust is it's kind of the same as if you have your bank account. So my bank account at Chase, I have full access and control to. If I put it into my revocable trust, I still have full access and control to. I can choose to nominate and appoint a co-trustee to have full access with me. I then can put the successor trustee to step in and the beneficiary provisions. So I can leave as many individuals, charities, sub-trusts for the people that I want to receive my assets, as opposed to just leaving the account in my name alone and putting the name beneficiary. It avoids probate, which again is something that most people are looking to do, but the assets that are held by your revocable trust do not avoid Medicaid eligibility. So a revocable trust is not the Medicaid asset protection tool that most people are looking to do. It's a great tool when we're looking to split assets, maybe from a tax planning perspective. So if we have a husband and wife who come to us, the idea in New York, because we don't have what is called portability. I know today it's been about 40 minutes and I'm trying to squeeze everything in to leave some time for questions. What that means is we need the if you and your spouse hold everything jointly, upon your passing, the survivor is going to receive everything by what we call operation of law. So in New York, the spouse who's passed is not utilizing any of their New York State exemption. So right now it's about, I think it's 6.2 million in New York that I can have in my estate before it's taxable or gifted. Federally, it's over 12 million. If me and my spouse each jointly own $12 million and I pass away, my surviving spouse still has $12 million and didn't get to use any of my 6 million tax exemption. So the idea in doing the revocable trust for a husband and a wife is they each create their own revocable living trust, and then we split the asset. So if one spouse has higher retirement accounts, those stay outside of the trust, but have a named beneficiary, and also recommended to have a contingent we're going to put more non-retirement monies in the revocable trust of the other spouse. Usually if there's real property, we're going to split the interest 50-50 into each trust. So again, it's not a Medicaid asset protection tool, but it's a good tax planning tool. Those revocable trusts can have the disclaimer trust provisions that I briefly discussed, meaning if my spouse dies and leaves me monies over the estate tax threshold, I can take all and leave the surplus above the threshold in the disclaimer trust so that it's not taxable. Irrevocable Medicaid asset protection trust. That's kind of the trust that everybody is interested in when they're looking to protect assets and do what we call the Medicaid planning. So benefits is 5 years after you've transferred your property and your non-retirement monies, all of the assets within the trust are now fully protected for nursing home Medicaid eligibility. So again, you have to effectively transfer the asset, but at the date of the transfer is when that 5-year clock starts. So if I transfer my home today on the 20th of July, technically I can apply without a penalty for nursing home Medicaid until August 1st of 2027. When and if the home care Medicaid look back goes into play, 2.5 years after you transferred the asset, you're now going to have that asset protected from a home care Medicaid standpoint. The way that the trusts that we handle for Medicaid asset protection are drafted, the grantors, so the person creating and transferring their home, are still entitled to the personal residence exclusion. So if the property is sold during lifetime, we may still have capital gains consequence, but you can offset the capital gains by the $250,000 personal residence if you're single, $500,000 if still married. So that is something that people like to hear. It is an incomplete gift for income tax purposes, meaning because the grantors have the right to use and occupy the residence and have basically a life estate, nobody can kick them out of the property. So that's kind of the sense of control that an individual likes to have. You're still responsible to pay any and all expenses of the property for which you reside in, your homestead. You can still keep all tax exemptions, so the STAR, Enhanced STAR, Veterans Exemption. Upon your passing, the beneficiaries will inherit the property at the stepped up date of death value. So really the benefit is we're protecting this asset. We're getting it out of your name into the name of your irrevocable trust, but you still are continuing as you have. You're still living in the house, you're still paying your bills, you're still entitled to your exemptions. If you're transferring maybe a brokerage account to your irrevocable trust, the discussion with the attorney is whether you want the trustees, because you cannot be the trustee of your irrevocable trust. I think that's in one of the detriments. So if I'm creating an irrevocable trust, I have to appoint somebody else. I cannot be a trustee. I do not have direct access to the principal, the assets within my trust, or the income that's generated. So you're always going to want to appoint an individual that you trust to manage these assets. Usually the way it's drafted, at least the way we handle it, is that as the grantor, I have the power to remove and replace my trustees. So if something's going on that I don't like or am not happy with, I can replace the trustee. I also have the power to remove and replace the beneficiaries. So I might not be able to go to Chase and make the direct withdrawal of the assets I put in. But if I feel that my trustee is not acting appropriately, I can replace them with somebody else. Because it's the incomplete gift, the assets are still includable in your taxable estate. The one thing to kind of be aware of, and again, I know this is a lot of information to take in within an hour. It's, very important to have kind of a case-by-case conversation of your own assets with an attorney. But if you create an irrevocable trust and you have one trustee, so a sole trustee, and they have the discretion to what we call invade or take any of the assets within the trust. They'll have what we call a general power of appointment. What that means from a taxable standpoint is if they predecease you, the assets within your trust are includable in their taxable estate. So when doing this type of planning, there's a lot of things to take into account, not only on your own taxable considerations, but also if you're using a sole trustee for them. The taxable estate is, again, what allows us to get the step up in basis and allows you to be able to be responsible to keep your exemptions, the personal residence exclusion, because it's not a completed gift of your home until you've passed. Children's trusts, these are a very popular tool to get some assets out of your name, usually from a tax planning perspective. So usually we're seeing a parent or a grandparent creating and funding a trust for their child or their grandchild. You, as the grantor, cannot be the trustee of this trust that you're creating. So in most scenarios, we have maybe husband creating a trust for each of the children and the wife is the trustee, or vice versa. The trust is set up either for life of the child or grandchild until a certain age, or maybe a specific event. There is a separate tax ID number for this trust. It is a completed gift, meaning you putting assets into it. It's recommended for you to speak with your accountant and file a gift tax return. The trustee that is on the children or grandchildren's trust can use the principal or the income for what we call the HEMS standard, or the health, education, maintenance, and support of the beneficiary, which is going to be that child or grandchild. Special needs trust or supplemental needs trust, also called SNTs. There's third-party SNTs, and then we have what are called self-settled or first-party SNTs. These are great planning tools if there is an individual that you are looking to transfer assets to that is disabled. So the self-settled or first party is monies that you are entitled to, but you're disabled, you're putting into your own trust. The third party is monies that somebody wants to give to you that they're assigning to a trust that was created for you. The self-settled SNT has what we call the Medicaid payback. What that means is if I'm disabled and I have my own first party SNT, monies that go into it that remain can be paid back to Medicaid that basically reimburse or recoup, make them full for the Medicaid benefits that I've received. The monies that we're putting into these SNTs do not impact or count towards the Medicaid eligibility thresholds that we discussed in the way beginning. So the purpose of these types of trusts is to allow for the beneficiary who is disabled to be able to maintain their benefits and their programs and essentially be supplemented. The trust cannot be used to pay for expenses that are already being covered by Medicaid, SSI, or SSD, Social Security Disability. You can't have a duplicate of expenses. It is, to supplement. So anything not related usually to food or shelter can be paid by the SNT. It's a very important tool if you have maybe a child or a grandchild who may be very young, but may have a disability that's going to impact them through adulthood, to not leave monies to them outright, but to discuss and set up one of these SNTs for them. Life insurance trusts. These are also a great tax planning tool. It's an irrevocable trust, and it's basically either purchasing a life insurance policy in the name of the trust, or you own a policy and now you're transferring the ownership. The trust basically owns and is the beneficiary of the policy, and it's either set up on one individual's life, or let's say for husband and wife upon the second to die. The death benefit when the insured passes either goes to the beneficiary outright, or we can have it continued within the trust. And after 3 years, so I transfer my life insurance policy to a life insurance trust after 3 years, that death benefit is not a part of my taxable estate. I think that leaves us about 5 minutes for questions. I hope that was very helpful. Lots and lots of information. I'm more than happy to have a more one-on-one conversation. We offer kind of a free consultation for anyone who has participated in these programs. My contact information is here on this last slide. You can call the office or shoot me an email if you have any specific questions that you maybe don't want to discuss today on the program, or want kind of to just review your own income and assets. But, again, thank you guys all so much for attending today. I think there's 2 or maybe 3 more in our series. But please, unmute if there's any questions, and thank you again.